is suing Walt Disney Parks and Resorts for the alleged wrongful death of his wife. He says that she died after eating food with dairy and nuts, despite telling the staff about her severe allergies. The lawsuit says the restaurant didn't have proper safeguards. But now there's a new legal hurdle after Disney pushed to throw out the lawsuit because the man signed up for a one-month trial of Disney Plus in 2019.
Chief Legal Analyst Khalif Rhodes joins us now. Khalif, court documents show the company wants the case to be dismissed because of the fine print in the trial for the streaming service.
That's right. Then the lawyer is calling the husband, or excuse me, the husband's lawyer. He says that Disney is being completely unfair here.
Yeah, I'm disturbed by any of this that I'm hearing. I mean, first of all, this man lost his wife, you know, and so you're telling me that I don't have an opportunity to bring a claim against you for some type of wrongdoing. Even if the courts decide that I was right, you're telling me I can't have my day in court because I signed up for an app to be able to stream your services, not to go to your park, but to stream your services. When I looked at the claim, it did talk about he purchased the tickets using his same user profile that he created to get the app. But I mean, he purchased the app to watch movies, not to go to the park, and clearly not to go eat food at this restaurant. His wife, who was an MD, told them about her medical condition. They ensured that they would take all the safe protocols to ensure that she got no cross-contamination. However, she did. Nuts, I mean, that's something that is problematic. Anybody that deals with that, I myself have 2 daughters that have nut allergies, that have seafood allergies. Anytime I go to a restaurant, I'm like, overly over the top, like, hey, they have allergies. I put the EpiPen on the table. I don't want them to die. Like, I'm over the top. I could assume this couple was the exact same way. If you're calling the restaurant to ensure that they do that, that's the hurdles that you have to do as a person that have life-threatening allergies. Now it's on you as the restaurant, as the park, to ensure that you can accommodate and cater to people like that, or you open yourself up for liability, which in this case seems like it's wide open.
And in this case, they're talking about the terms and agreement that he signed for the Disney Plus service, which, looking at the case, it says that he either canceled it or let it expire. So if you signed up to something that you no longer receive, are you still bound to those terms and agreements?
If you signed the agreement and it says, and I looked at the language, it does say all Disney complaints. And so that's the argument that they're making, that we are a Disney entity. We're one Disney. We're not broken down into separate, different entities. And because we are not, if you're attempting to bring this claim against us, they're not saying that it wants to be dismissed. They're just saying stay, which means pause, don't allow this to go forward until we go to arbitration. Now, obviously, arbitration is binding, so whatever happens in arbitration would, in essence, get rid of the case. But they're saying that because you signed up for this app, and this app allowed you to go to arbitration, I should say required you to go to arbitration for anything against Disney, they're saying, hey, this is against Disney, it should go to arbitration. And for good reason for Disney. An arbitrator is likely to give them a way better outcome than a jury of his peers. A jury of his peers hears this story, listen to these facts, here's about a medical doctor, they'll start calculating loss of potential wages in the future. They talk about the punitive damages. It could be, you know, skyrocket. I mean, you can see these major, like $150, $200 million complaints where there may be a little bit of damages for medical, but the punitive damages could be, you know, enormous. And I think that's what they're attempting to avoid, because an arbitrator is not giving you those type of punitive damages.
So what do you think, Black and White? Is this going to be able to, are they going to avoid arbitration? Are they going to get their day in court the way they want to? I mean, because one hand you have the language which they signed. What happens?
I don't think a judge is going to say that you were signing up for that. I think if it was something that happened with the app, if somehow the app caused the house to burn down or something, you know, whatever, some strange facts happened, and it was like, wow, I used this app and I jumped over the arbitration and I went to sue you. Yes, I think the judge would say, you missed a step. You're supposed to go to arbitration. I think this is an extremely strong step, big leap for Disney to say that that language in the app's, you know, terms of conditions that no one is reading. Everyone's swiping through it and clicking as fast as they can so that whatever you're trying to get through opens. No one's saying, well, let me look at this with a fine print. So because of that, I think the judge will say that this will continue in court and they'll have their day in court.